They say a man's home is his castle, but in Willow Lake Estates, the HOA seemed determined to turn mine into their personal kingdom. When that foreclosure notice appeared on my door, I knew this wasn't just about some disputed fines anymore. This was war. Before we get into this story, I want to hear from you folks in the comments. What's the most ridiculous thing your HOA has ever tried to pull on you? Share your experiences below, because I have a feeling mine isn't as unique as I thought. My name's Frank, and I've lived in Willow Lake Estates for 22 years. My wife, Margaret, and I bought this place back in 2001, right after I retired from the military. We'd saved our whole lives for this modest 3-bedroom with the view of the lake. Margaret passed 5 years back, cancer took her, but this house, our home, still had all our memories. When we first moved in, Willow Lake was paradise. The HOA was just 5 neighbors who met monthly to discuss community improvements. We had block parties, holiday decorations, competitions, and everyone knew each other's names. The annual dues were $300 and covered basic landscaping and pool maintenance. But things changed around 2015. New people started moving in, folks with money and big ideas. The original HOA members either moved away or got voted out. By 2018, our quiet community board had transformed into a bureaucratic nightmare, with 10 pages of covenants and a president who treated the position like her personal fiefdom. That president was Linda, though everyone called her President Davis, with the kind of reverence usually reserved for actual heads of state. She was in her late 50s, perfectly coiffed, with a smile that never reached her eyes. She ran the HOA meetings like a drill sergeant, complete with a gavel she'd bang whenever someone dared question her authority. My first run-in with the new regime came in July of 2020. I'd planted a small vegetable garden in my backyard, nothing fancy, just some tomatoes, peppers, and zucchini. Margaret had always wanted a garden, and I figured it was time to finally make that happen. 2 weeks after I'd put the seedlings in the ground, I found a violation notice in my mailbox. Unauthorized garden structures, it read, citing a rule about maintaining aesthetic uniformity. The fine was $150. I went to the next HOA meeting to contest it. Linda sat at the head of the table like a queen holding court. "Mr. Henderson," she said, barely looking up from her papers, "your garden violates Section 7.4 of our covenants regarding unapproved vegetation." "It's a vegetable garden," I said, keeping my voice steady. "In my backyard. How does that affect anyone?" "The rules are clear," she replied, tapping a perfectly manicured nail on the document. "All landscaping must be approved by the architectural committee. You didn't submit an application." I looked around the room at the other homeowners. Most wouldn't meet my eyes. The previous HOA never required applications for vegetable gardens. "We've updated the covenants," Linda said with a tight smile. "It's all in the meeting minutes. You should attend more regularly." I paid the fine, but I didn't remove the garden. What were they going to do? Fine me again? They did. Every month for 3 months, I received another 150 violation notice. By October, I'd racked up $600 in fines, plus administrative fees. That's when I decided to fight back. I spent a week researching Arizona HOA laws. What I discovered shocked me. Under state law, HOAs couldn't fine homeowners more than $1,000 total for a single violation without taking the homeowner to court. They also couldn't continue issuing fines for the same violation once the homeowner had been notified. Armed with this information, I sent a certified letter to the HOA board, citing the relevant statutes and demanding they cease the fines. I received a terse response acknowledging receipt, but stating their fines were legitimate and enforceable. The fines stopped, but the harassment didn't. In November, I received a notice that my fence, original to the property when I bought it, was now in violation of the height and material restrictions in the updated covenants. The fine, $500 plus $75 per day until corrected. You wouldn't believe what they did next. When I went to measure the fence, I found that someone had spray-painted bright orange marks all along the sections they claimed were too high. They'd trespassed on my property to mark up my fence. I documented everything with photos and sent another letter, this time to a lawyer friend who dealt with HOA disputes before. He advised me to request a hearing with the board, which I did. The hearing was a farce. Linda and her board members sat behind a long table while I was given a single chair facing them like I was on trial. "Mr. Henderson," Linda began, "we've received multiple complaints about your property." "From whom?" I asked. "I've never spoken to any neighbors who had issues with my home. Complaints are confidential," she said smoothly. "The fact remains, your fence is in violation, as is your garden. And we've now noticed your mailbox doesn't conform to community standards." "My mailbox? It was the same one that had been there since 2001. "This is harassment," I said, my voice rising slightly. "You're targeting me specifically because I questioned your authority with the garden fines." Linda's smile was cold. "We enforce the covenants equally for all residents, Mr. Henderson. Perhaps, if you were more compliant, you wouldn't find yourself in this situation." The hearing ended with them giving me 30 days to bring everything into compliance or face additional fines of $1,000 per violation. I left that meeting feeling defeated. My lawyer friend said I had a case, but it would cost thousands in legal fees to fight them in court. On a fixed retirement income, that wasn't feasible. If this HOA sounds unbelievable already, make sure to hit subscribe. You don't want to miss how this ends. For the next few months, I tried to fly under the radar. I replaced the mailbox with one that met their specifications, costing me $450. I modified the fence to the exact height they wanted, another $800. But I refused to remove Margaret's garden. That was my line in the sand. In January, I received a letter that made my blood run cold. It was a notice of default, stating that I owed $3,750 in unpaid fines and fees, and if not paid within 30 days, the HOA would begin foreclosure proceedings. On my home, they couldn't be serious. Foreclose over a garden and some fence modifications. I called my lawyer friend immediately. He was as shocked as I was. "Frank, this is extreme even for power-hungry HOAs," he said. "They're bluffing. No court would uphold this." But they weren't bluffing. 30 days later, I came home to find a foreclosure notice taped to my front door. My hands shook as I read it. The HOA, through their attorney, was initiating foreclosure proceedings over the alleged debt. That night, I barely slept. This house, my home, was all Margaret and I had built together. I couldn't lose it. Not like this. The next morning, I drove to the county courthouse and pulled every document related to Willow Lake Estates HOA. I spent hours at a table in the records office, going through incorporation papers, bylaws, meeting minutes, and financial reports, and that's when I found it. Buried in the 2019 financial statements was a note about the HOA's insurance policy. It had lapsed in June of that year and hadn't been renewed until January of the following year. According to Arizona law, HOAs are required to maintain certain types of insurance at all times. Operating without that insurance for 7 months meant the board had violated state statutes, but there was more. As I dug deeper, I discovered that the HOA hadn't properly notified homeowners of covenant changes as required by law. The updated covenants they were using to fine me had never been properly ratified by the membership. I felt a surge of hope, but I knew I needed more evidence. That evening, I drove past the community clubhouse and noticed the dumpster outside was full from what must have been a board meeting. On a hunch, I pulled over, put on gloves, and started going through the trash. Among the discarded coffee cups and meeting agendas, I found gold, shredded financial documents that someone had been careless enough not to cross-cut. I carefully collected the pieces, took them home, and spent the next 3 days piecing them together like a puzzle. What they revealed was damning. The HOA board, led by Linda, had been misappropriating funds. They'd increased the annual dues from $300 to $200 over 5 years, claiming rising maintenance costs. But the documents showed they'd been using HOA money to pay for personal expenses, including Linda's daughter's wedding venue deposit and a luxury vacation for the board members. I now had everything I needed: proof of insurance violations, improper covenant changes, and financial misconduct. I contacted my lawyer friend, who agreed to take my case pro bono once he saw the evidence. The court date was set for late April. As the day approached, the tension in the neighborhood was palpable. Some neighbors whispered support when they saw me, while others crossed the street to avoid me. Linda and her board members maintained an air of confidence, telling anyone who'd listen that they would make an example of me. In the courtroom, Linda and her board sat smugly at their table with their high-priced attorney. I sat with my lawyer, a folder of evidence, in front of me. The judge, a no-nonsense woman in her 60s, listened as the HOA's attorney presented their case. He painted me as a defiant homeowner who repeatedly violated community rules and refused to pay legitimate fines. Then it was our turn. My lawyer methodically presented our evidence: the insurance lapse, the improper covenant changes, and most damningly, the financial misconduct. When we displayed the reconstructed documents showing the misappropriation of funds, the atmosphere in the courtroom shifted. Linda's face went pale. Her board members shifted uncomfortably in their seats. The HOA's attorney tried to dismiss the evidence as irrelevant and improperly obtained, but the judge wasn't having it. "This is serious," she said, looking directly at Linda and her board. "These allegations go to the heart of whether this HOA has been operating legally and ethically." After hearing both sides, the judge didn't rule immediately. She said she needed time to review the evidence and would render a decision in 2 weeks. Those 2 weeks were the longest of my life. I went about my daily routine, but always with a cloud of uncertainty hanging over me. Would the judge see the truth? Or would the HOA's expensive attorney manage to spin things their way? Finally, the day arrived. I walked into the courtroom to find it packed with neighbors, some supporting me, others there to see Linda get her comeuppance. The judge entered, and the room fell silent. She reviewed her findings, her expression unreadable. Then she looked up. "After careful consideration of the evidence presented," she began, "this court finds that the Willow Lake Estates HOA has engaged in multiple violations of state law and their own governing documents." A murmur went through the courtroom. Linda's face was ashen. "Specifically," the judge continued. The HOA operated for 7 months without required insurance coverage, failed to properly notify homeowners of covenant changes, and misappropriated association funds for personal use. She paused, looking directly at Linda. Furthermore, the attempt to foreclose on Mr. Henderson's property over disputed fines constitutes an abuse of power and a violation of the HOA's fiduciary duty to its members. The judge then delivered her ruling. Not only was the foreclosure dismissed, but all fines against me were voided. She ordered the HOA to reimburse me for all expenses I'd incurred to comply with their improper demands. Most significantly, she dissolved the current board and ordered new elections with oversight from the court. As the gavel came down, I felt a weight lift from my shoulders that had been there for months. The look on Linda's face was priceless. A mixture of shock, outrage, and fear. After the ruling, several neighbors approached me, thanking me for standing up to the board. Even some who had previously avoided me now shook my hand and offered congratulations. The irony wasn't lost on me that Linda, who had tried so hard to make an example of me, ended up being the example herself. She and her board members were removed from their positions, and the new board, elected with proper oversight, included several neighbors who had quietly supported me all along. In the months that followed, Willow Lake Estates began to transform back into the community it once was. The excessive covenants were revised to be more reasonable. The annual dues were adjusted to reflect actual expenses. And my vegetable garden? It became the pride of the neighborhood, with several other homeowners starting their own. Sometimes, on a quiet evening, I sit on my back porch, looking at Margaret's garden, and think about how close I came to losing everything. I didn't set out to be a hero or start a revolution. I just wanted to tend my garden in peace. But I learned something important through all this. Power doesn't respect boundaries unless someone enforces them. HOAs are supposed to serve the community, not control it. When they forget that, it's up to people like you and me to remind them. So if you're facing down an unreasonable HOA, remember my story. Document everything, know your rights, and don't be afraid to stand your ground. Because your home is your castle, and nobody should have the power to take that away from you. If you enjoyed this story, make sure to hit that subscribe button and ring the notification bell so you don't miss my next HOA revenge tale. And if you've had your own run-in with an unreasonable HOA, share your story in the comments below. Let's show these power-tripping boards that homeowners have rights too.